Good morning. My name is Gaurav Mukherjee and I am currently affiliated with the Azim Premji University in Bangalore. I graduated from the Nalsa University of Law and was a practicing advocate in Bombay prior to becoming currently affiliated with the Azim Premji University. Today I'll be talking to you about the idea of judicial review in a comparative constitutional law context. Now, the manner in which this presentation will proceed is that I'll be introducing to you what the idea of judicial review is and the kinds of forms that it currently takes. Then I shall be moving on to the idea of judicial review as it is manifested in various common law jurisdictions across the world. And I'll be telling you a little bit about how the idea of judicial review can be applied in a comparative context in India. And then finally, I'll be concluding and explaining to you why it is important to think about the idea of judicial review in a wider comparative constitutional law context. Now, judicial review occurs when a court examines governmental legislative activity on certain grounds which are usually provided in the nation's constitutional documents. Now, what exactly are the kinds of judicial review which can happen? Judicial review of legislative action can occur under three distinct yet related circumstances. Now, the first is when the court can decline the application of a statutory provision of a law in a particular case. The second instance is where a court, in its interpretive role, can modify the effect of a statute in a given circumstance to ensure that it is in conformity with another legal right which may be present either in a statutory or a constitutional context. The third is where the court strikes down one or more provisions of a statute, and the final is a finding of incompatibility, and this occurs very rarely but is present in jurisdictions such as the United Kingdom, which does not currently possess a written constitution and therefore is reliant on statutory and international law for its process of judicial review. Now, I'll give you an example for each of these kinds and which one is particularly applicable in a context like India. The next part of the presentation will address the philosophical and historical foundations of the idea of judicial review. Now, most trace the idea of judicial review back to the writings of Thomas Aquinas, who stated that there is neither a legal nor a moral obligation to obey an unjust law. Others also regard it as one of the only legitimate means of guarding a nation's constitution. And the earliest instance that one finds of the idea of judicial review is the doctrine of graphi paranomon, which existed in ancient Greece. Now, this was documented by Aristotle and Plato. And the manner in which the idea worked was that a legislator, if he introduced an unconstitutional legislation in the Senate, then if it was deemed to be unconstitutional by his peers, what would happen is that there would be a criminal liability which actually accrued to the legislator in question. In Western legal tradition, of course, this idea was first enunciated in Dr. Bonham's case, which occurred in the UK. Now, Dr. Bonham's case involved a particular legislation which had been passed by the Parliament, which allowed the Royal College of Physicians to prescribe certain conditions under which a physician could practice. Now, Dr. Bonham was the petitioner in question, was imprisoned by the Royal College of Physicians when he continued to practice without a license from the institution. Now, Lord Coke, in fact, was the person who delivered a very radical judgment, which completely flew in the face of the idea of parliamentary sovereignty, which is a key notion in the United Kingdom. And he stated that the law was in fact unjust, and he struck it down. Now, this, of course, did not find great support in the common law tradition in the United Kingdom, and most disregarded it, and there was a quick revert back to the idea of parliamentary sovereignty as being a highlight of the political system present in the United Kingdom. Now, moving on a little further, we come to the case of Marbury versus Madison, where the United States Supreme Court in fact assumed a jurisdiction upon itself to judicially review a statute despite it not being present in the textual provisions of the Constitution. Now, there were some other instances, of course, where the idea of judicial review was present, and one of the most notable instances were the charters which were given to various commercial establishments, such as, for instance, most notably the East India Company, where there was in fact a charter in place which was promulgated by the Crown, and the governance of the colonies which were under these commercial establishments had to be in accordance with the statute, and the East India Company, for instance, could not pass a law which would be in contravention of this charter. Judicial review in India originates from the textual provisions of the Constitution, and most notably from Article 13. Article 13 states that any law which is inconsistent with the rights contained in Part 3 of the Constitution, which is the fundamental rights, are void. However, Article 13 explicitly excludes constitutional amendments passed by the Parliament from its ambit, and this is why there is the necessity to test all constitutional amendments on the grounds of basic structure, which is the second kind of review which we will be coming to very shortly. Now, the Supreme Court has the power to declare a law which is brought in front of it in a dispute before it to be unconstitutional to the extent that it clashes with the exercise of a fundamental right contained in Part 3 of the Constitution. Now, inconsistency with the Constitution of India may be further declared due to a lack of legislative competence, which basically means that if the legislature of a particular state passes a law which is, for instance, contained in the Union list, then that law will be declared to be unconstitutional by a particular court due to a lack of legislative competence. Now, a second ground on which judicial review can occur is the delegation of an essentially legislative function or an excessive delegation of power. Now, another ground on which judicial review can occur in this section is a contravention on the limits of legislative power which is imposed by the Constitution of India. Now, constitutional review is applicable to all laws made by government instrumentalities except for constitutional amendments, and Articles 32 and 226 grant the Supreme Court and various high courts to rule on violation of fundamental rights. Now, the second ground of review which we will be looking at right now is called the basic structure review. Now, the basic structure review originated from the case which is called Keshwananda Bharati versus Union of India, where a certain land reform statute was brought before the Supreme Court in review, and the Supreme Court ruled that there was such a thing as the basic structure of the Constitution, and it identified certain key elements of it, and various judges, of course, there was no degree of unanimity on what constitutes the basic structure. But why the basic structure review is very important is because of the fact that all constitutional amendments need to be tested on on the ground of basic structure. And one thing that is very important to note about the basic structure review is that it is not applicable to ordinary laws, which obviously are taken care of by the other section, by the fundamental rights review which we spoke about previously. The reason why basic structure review is so important in Indian constitutional democracy is because of the fact that it limits legislative action, and there are certain inviolate things which the government cannot take away through legislative action. So what that means is that if today the government wished to make the position of the Prime Minister to be one which can be held in perpetuity, that is not something that could actually happen because of the fact that the basic structure of the Indian Constitution contains democracy as a vital component, and this would be completely eroded as a result of such an action. So therefore we see that judicial review of any governmental legislative action on the grounds of the basic structure is very important and is fundamental to the governance of this country. Now, judicial review has been held to be part of the basic structure as well, and this means that any kind of legislative attempt to take away the power of judicial review has been very strictly struck down. Now, coming to the kinds of judicial review that exist across jurisdictions today, there are actually four kinds. The first kind is where a court can decline the application of a statutory provision in a given case. Now, how this can occur is the court simply says that the given factual matrix is just not consistent with the legal provision that exists. Now, the second instance is where the court, in an interpretive role, modifies the effect of a statute in a given circumstance to ensure that it conforms with another legal right, which may either be constitutional or statutory in nature. Now, the third instance is something that is much more common in India, which is where the court strikes down one or more provisions of a statute. Now, this may happen, especially in the case of India, where the given statute is not in conformity with one or more provisions of the Constitution or lacks legislative competence, and this is something that we shall be discussing further in this presentation. Now, the final category is one which is relatively rare and is often confined to a jurisdiction like the United Kingdom, which is where there's a finding of incompatibility between a particular law which has been passed by Parliament, and if it is not in conformity with either the international obligations of a particular nation, or if it is inconsistent with a broad legislation like the Human Rights Act of 1998, which exists in the United Kingdom, then what the court can do is it can declare that a particular legal provision is not in compatibility with its international obligation or an overarching legislation such as the Human Rights Act, as I specified. Now, in terms of an Indian context, it is very important to examine the third category, because the third category is where most legal contestation occurs, which is when there is a clear conflict between a statutory provision with a provision in a constitution, and therefore it gets struck down on account of the fact that it is so inconsistent. Now, one of the more notable instances of such an act was the case concerning Indira Gandhi versus Raj Narayan, where Indira Gandhi, after having lost the election, sought to put the position of the Prime Minister beyond any judicial review, and this was in fact struck down, and the Supreme Court stated that judicial review was a very essential part of the Indian democratic fabric. It was a part of basic structure, and any attempt to legislate away the idea of judicial review would not be valid and would always be struck down. Now, one important debate which is important to keep in mind is the debate concerning tribunals in India. Now, there has been a move to establish tribunals such as the Central Administrative Tribunal, the National Tax Tribunal, which in fact in certain instances takes away the jurisdiction of the High Court and the Supreme Court to sit and appeal over a decision passed by it. Now, the reason why tribunals have been advocated as a possible policy solution to India's great judicial backlog is because of the fact that it is more specialized and it often lacks the formality which is associated with a court. Now, however, most recently in the case concerning the Madras Bar Association versus the Union of India, the Supreme Court of India held that the National Tax Tribunal was unconstitutional since it took away the jurisdiction of the High Court and the Supreme Court to sit in review over certain actions passed by it. Now, as I said before, the Supreme Court has always vehemently resisted any legislative attempt to take away its power to sit and review over any decision passed by a lower court. The next section of my presentation will address the issue of method in comparative constitutional law, because one must be very careful whilst using foreign law in an Indian context. Now, the manner in which I have identified and selected jurisdictions for presentation in this talk on comparative constitutional law and the idea of judicial review as embedded in it has been to identify jurisdictions which have been previously employed by the Supreme Court in its decisions. Now, one must always remember that constitutions are very particular to a particular nation and are necessarily embedded in its historical and political thought. So one must again be very careful while selecting jurisdictions when using them in a comparative constitutional context. And one of the manners in which one can go about doing this is to ensure that you use cases from a jurisdiction which has been used by your country's Supreme Court. So I have particularly chosen jurisdictions such as South Africa, the United States and the United Kingdom because of the fact that their jurisprudence has been employed by the Supreme Court in its decisions and can therefore serve as an effective guide and when delivering decisions. Now, the next section of my presentation will address the idea of judicial review in a South African context. Now, the reason why I have chosen South Africa is not only because of the fact that South African jurisprudence has been employed by the Supreme Court in many of its judgments on socio-economic rights, but I also think it's important because India and South Africa are very similarly situated in terms of the guarantees that it gives to its people and because of similar trajectories of political development. Now, the idea of judicial review in South Africa is contained in Section 2 of its constitution, which states that this constitution is the supreme law of the republic and any law which is inconsistent with it is invalid and the obligations imposed by the constitution must be fulfilled. The next section will address the issue of judicial review in the United States. There has been great debate in the United States about whether judicial review should even exist given that it is absent from the textual provisions of the Constitution and because of the fact that each decision concerning judicial review of a particular legislation has often been played out in a counter-majoritarian way and because of the fact that many scholars are of the opinion that each judge of the Supreme Court brings to the table his or her own political ideology and often thwart governmental efforts to introduce wide-ranging reforms. For instance, if I could just point out, there have been many constitutional challenges mounted to the Affordable Health Care Act, which is popularly known as Obamacare, and there have been concerns that President Obama's attempts to reform the state of healthcare in the United States could be thwarted by constitutional challenges which would be mounted on such an act. Now, judicial review actually originated in the United States through the famous case of Marbury versus Madison. Now, the case invoked the original jurisdiction of the Supreme Court and prayed for a writ of mandamus requiring the erstwhile Secretary of State, James Madison, to set up a commission to appoint Mr. Marbury as a Justice of the Peace. Now, discussing the Judiciary Act of 1789, the Supreme Court stated that any legislation which is repugnant to the Constitution was void. The opinion further went on to discuss in detail why Mr. Marbury had a right to his commission and why the writ of mandamus was the proper remedy and why the Secretary of State was the proper object of judicial action given that he was a functionary of the government. Now, since then, the doctrine, of course, produced some horrendous results in the case of Dred Scott versus Sanford, where the court struck down the legislation for the first time since Marbury and denied persons of color standing before the Supreme Court. Now, of course, the 1886 case of ex parte Milligan again highlighted the great political contours within which the right of judicial review is located. Now, the consistent concern which has been expressed about judicial review has been about how the Supreme Court is inclined to rule in accordance with national meta-narratives, prevailing ideological and cultural propensities, and how many of its decisions have come to be in line with the interests of ruling elites. My next section will address judicial review in the United Kingdom. Now, this is somewhat of a misnomer in this particular context, given that the United Kingdom is very concerned with the idea of parliamentary sovereignty. Now, there's been a historical unease between the exercise of royal power and the need to share that power with a body of elected representatives. Now, a series of reforms beginning in the late 17th century saw a limitation on the power which is granted to the monarchy. Now, with these series of reforms, the parliament, rather than being seen as a body which could violate the rights of the people, was seen as an institution that could in fact safeguard the people against abuses of royal power. Now, this is one of the reasons why there has been a historical trust which has been reposed by the British in its parliament, and this brings us to the idea of how parliamentary sovereignty is very important in the polity of the United Kingdom, and how judicial review only very recently became part of the British political system through the Human Rights Act of 1988. Now, the Human Rights Act of 1990. The Human Rights Act of 1998 was passed due to Britain's obligation to bring its domestic law in uniformity with the rights granted under the European Convention of Human Rights. Now, one thing which is very important to appreciate is Section 3 of the Human Rights Act. Now, it is very important to read in full what the section states. The Section 3, which is titled Interpretation of Legislation, states that so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way in which it is compatible with convention rights. Now, what this means is that the Human Rights Act establishes rules of construction that must be followed unless they are, of course, contradicted by legislation, which is something that the United Kingdom government has never done. Now, some superior courts can declare legislation to be incompatible with any of the convention rights, and if they state that it can't be interpreted in any other way apart from the fact that there has been a clear divergence between the rights guaranteed under the convention and the supervening legislation. In pursuance of this, what can happen is that the court can make a declaration of incompatibility. Now, the legal effects of a declaration of incompatibility are slightly unclear. It does not bind parties before a court, nor does it affect the operation of the provision in respect of which the declaration is made. Instead, what it does is that it serves to signal to the government and the parliament a non-binding recommendation to reconsider the legislation or the provision in light of the declaration. Now, a manner to remedy this is through an act of parliament. However, it offers an alternate means where the minister states that the existence of compelling reasons where the minister can in fact remove the incompatibility by using subordinate legislation to amend the offending act which has been passed by a parliament. Now, this brings us to my conclusion, and what we have learned today is that judicial review is an instrument of ensuring checks and balances within a particular government and within a larger political system. What we've looked at today in my presentation has been the historical and philosophical underpinnings of judicial review, the manner in which it is manifested in other jurisdictions such as the United States, the United Kingdom and South Africa, and the way in which judicial review can occur in the Indian context. I have also provided you examples of the manner in which judicial review occurs in India and the two kinds of reviews which are present in the Indian constitution and in the broader Indian political context. Now, I hope this is going to be helpful, and I hope that you will appreciate how important the device of judicial review is in a political system and in an open democratic society. Thank you.